Hello, my name is Chris Cotter with USLAW member firm Roetzel and Andress in Ohio.
And I'm Michael Judy from USLAW member firm Dysart Taylor in Kansas City, Missouri.
Our topic today is negligent supervision of drivers due to remote workforces and contactless monitoring. Now that's a mouthful, but I think this is going to be an issue that we're going to see even after the world goes back to normal or some semblance of it. Mike and I talked about this topic and realized there's really a lot of sub issues involved. And so we're going to first start off by exploring some of those issues. Mike, you want to start us off?
Yeah, the first one, and it's particularly relevant now with kids going back to school, sporting events starting to open up with fan participants, and it's what do you do to monitor people for symptoms of COVID or for people who have COVID themselves? And particularly in the transportation world, it's what can companies do to ensure that their drivers who are all over the country, who are always on the move, how can you ensure that those drivers who have COVID, may have been exposed to COVID or have COVID symptoms, are not driving, and do they have a duty to do so? What's their responsibility to the public at large, to their customers, to the people they come into contact with? Dovetailing off of that, what's their liability to an individual if one of their driver infects somebody and they haven't been monitoring for symptoms, they haven't been doing testing? Off that, is there a requirement? Is there a duty to provide PPE for drivers, not just for their own personal protection, but for the protection at large? And Chris, that dovetails well into monitoring and the next topic that you're going to be talking about.
Yeah, I mean, I think those are the major issues. Another one I had thought of is reasonable suspicion drug and alcohol testing. Obviously, motor carriers do that when there's a reasonable suspicion. In today's world, that's a little bit different. It presents new challenges. You're not always in front of drivers, and yet at the same time, you want to make sure that's being done, and you have those opportunities. We can see claims, coming forward out of this where perhaps someone wasn't monitored or should have been, and so I think that could be an issue moving forward in cases.
Yeah, and another issue, I know, Chris, you and I have discussed this, and we've had questions from clients about this, is we all know that one of the very first claims that comes at a company after an accident is negligent hiring, negligent training, negligent supervision. So how can companies now monitor their drivers for attendance at safety meetings, which is always one of the first things you'll get? Here's your record of attendance. Is that required to be done by Zoom now? Are we off the hook for doing those in person? If you do them by Zoom, how are you going to make sure that your driver attends? Is it via roll call? Is somebody going to be there taking attendance? And off of that, what do you do with a driver who doesn't have a modern cell phone with a camera, can't hop on real easy? What if they're not in a place where they have Wi-Fi, where they can hook up a computer and attend one of those meetings? What duties does a company have to provide that equipment so a driver can do it? And I know these are only three small issues and of a myriad of issues that you and I've discussed, but I know the next question is going to be, all right, we spotted the issues. What do we do next, Chris?
Right. I mean, to give some thought to that, we've identified the issues, but I think as we see claims come along, and we will, really the applicable law, I think, is going to be state law on negligent hiring or negligent supervision. That state law is typically ordinary care. It is what it's always been, whatever it is in your state. Ordinary care, the ordinary measures that you need to take. So I think that's going to be the law that will apply. However, we also will be faced with and need to be aware of whatever state laws and regulations have come out since COVID that may apply today, may have applied the last 6 months. Now, looking ahead for me to defend or Mike to defend one of these claims 2 years from now or whenever, I'll be looking to see if my company has been taking measures and doing what it can or what it thinks is best to prevent spread of the virus, to put reasonable measures in place. And of course, I want, if there are applicable regulations or statutes, I hope you're aware of them and doing your best to comply, because we all know that there can be interpretation of those and different ways to apply. As long as you're making the effort, I feel I can defend a claim of negligence or supervision, whatever theory they throw at us or whatever angle they come at it. I think that's something we can defend.
Yeah, I agree with you 100%. And I think trying to do something that's reasonable is better than doing nothing and saying, I don't have the answers. But we know these things are coming down the road, so we better be prepared to handle them.
Right. Well, that's all the time we have. Thanks for joining us today.
Thank you, everybody.